the SEQ sequence. So I guess the council has authorized us to undertake that and have George Ritter come up with a plan for it, or come back to the planning board. So I don't. Any comments on that or
Mr. Chairman?
Explanation?
Mr. Chairman, can you hear me?
Yes.
Sorry. I have a suggestion, probably benefit everybody. This did originate at council, and George at council made a brief presentation as to what it does and what it may or may not do. And it may be worthwhile to have him give that. It's brief, but it's informative. Maybe he could do that for the benefit of the members tonight.
Are you willing to do that, George?
Yes, yeah, that's not a problem. Well, essentially, what his council is asking the planning board to take a look at is a series of properties. The first step will be to determine whether they are in need of redevelopment. That's basically looking at these properties and seeing if they are properties that we think is worth or appropriate to include in a redevelopment zone. The second part of this, after we go through that process, determination is made, the second process will be to actually develop a redevelopment plan or a combination of redevelopment plans for the areas that are selected as being in need of redevelopment. So it's a two-step process. As I say, the first process will be really looking at these different properties and trying to determine if they meet the criteria to be designated a redevelopment area. After that is done, then the next step would be to actually look at whether or not, or what plans we should develop for these areas, redevelopment plans. And as I said, it might be one redevelopment plan with different phases or several redevelopment plans, depending on where these properties are located in the township. It's a two-step process. It involves data collection and assembling these things, and then having various meetings with not only the planning board, but I assume with the stakeholders that are going to be involved, the properties that are determined to be in need of redevelopment with the actual stakeholders in those properties. It's a process that I think will extend over several months to go through in terms of holding the public hearings that will be required, and to get the input of the various groups that will be interested in these plans.
George, could you identify the properties we're talking about relative to some landmarks?
Well, I think I don't know if I can get them all, but essentially the area that we're looking at is the area of the township associated with the Phillipsburg Mall. The primary redevelopment area is obviously the remaining portion of the mall. The second larger parcel is the area behind the mall. That is the adult, that's referred to here as the it's the active adult residential community. And then there was an interest in looking at the properties directly across from the mall, where the Tasty Freeze was, the soft ice cream place, where the storage area is located out there. That's the primary focus of what's going to be looked at, those areas. And see if they can be incorporated into a consistent plan of how the town might like to see that area developed or redeveloped in the future.
Could I clarify that? Just the ice cream place, I believe, is actually in Peaburg. Then there's a small self-storage, and then Lopat starts just west of that, and we would go all the way down the highway to the Christmas tree farm. Does that sound right, George?
Yes. Well, that sounds better than my description. The landmarks out there that I remembered was the Tasty Freeze, but yes, that's the general area.
All right, that's generally Route 22, both sides, excluding the Ingersoll Rand property then.
Yes, which was developed under a previous redevelopment plan.
Thank you. So the council is authorized us to undertake this study. So have a motion to approve the resolution.
Well,
Like to-
council, I'll make that motion.
Thank you. Do I hear a second?
I'll second it.
Beth, may I have a roll call, please?
Yes. Member Weimer,
Yes.
Hoyle,
yes,
Member Pryor,
Yes,
Member Sampson,
Yes.
Member Weeks,
Yes.
Mayor Mengucci.
Yes.
Vice Chairman Fishback,
Yes.
Chairman Van Fleet.
Yes. Thank you all. Hey, where are we here? Under new business, I think we're to the point where we have two applications for completeness. One is the NFI Real Estate LLC application, preliminary final site plan for block 99, lots 3.01 and 6 for completeness only. Is the applicant on?
Yes,
Here.
good evening, Mr. Chairman. Mark Peck with the Florio Prucci Law Firm on behalf of the applicant NFI Real Estate LLC.
Good evening, Mr. Peck. How are you doing?
I'm fine, thank you.
Good. Would you care to proceed with the presentation you would have?
Yes,
or-
thank you. Thank you very much, Mr. Chairman, members of the board. Again, for the record, my name is Mark Peck. I'm an attorney with the Florio Prucci Law Firm here on behalf of NFI Real Estate LLC. We're here tonight only for a completeness determination on the application for preliminary and final site plan approval with bulk variance relief and design waivers. That's for property located at 188 Stryker Road, which is lot 3.01 in block 99. And there's also a proposed access over lot 6 in block 99. Now, we did receive both the Mazer and the Ritter January 22 reports. We'd like to address some of the comments contained therein. And we also have with us our engineer, Kyle McKenna from Bowler Engineering, to address some of the more technical concepts. So moving down, the first item is checklist item 62. I'm referring to the Mazer report. This is on page 4 of 6. The comments on the preliminary site plan details checklist is halfway down that page. So Mr. Sturbins and Mr. Wisniewski noted the following deficiencies. The first is checklist item 62, which is the consistency determination from the New Jersey Highlands Council. Now, this is an interesting conundrum because, you know, we did file for the consistency determination, but by the terms of the Highlands Council's, their own application for this, it states the Highlands Council will only conduct a consistency determination under this application where an application for development has been submitted to a municipality and the municipality has determined that such Highlands Council review is required. So obviously the review is required. We've submitted our application. The Highlands Council personnel, they're going to be on site tomorrow. So we do expect this determination soon, but obviously we don't have it this evening. And we understand that it is sort of a mandatory non-waivable feature. But we did want to note for the record that this is underway. So presumably the next time the board meets, we will have satisfied this condition. The next item has to do with checklist item per ordinance 2020-09. And this is a review by the township sewer engineer regarding available capacity. Now, this is interesting, and we actually object to this comment because while I understand that this ordinance apparently was adopted, it doesn't appear on the checklist, this requirement. This ordinance apparently amended or created a new section 243-43F in your zoning ordinance. But if you go to the township website and look at the ordinance book, it's not there. section 243-43 ends at subsection E. So this hasn't made it in there. And then you go to the website and you look in the new ordinances section of the website, and that's not there either. The new ordinances end at ordinance 2020-02. And while we certainly recognize the board, has every right to request this information, and we're going to need, when we get to public hearing, we're going to need to provide this information and satisfy the board as to these issues. But as for completeness, I submit that this is an improper completeness item because it does, for the reasons I just stated. And beyond that, we have been for close to a year been trying to get some response from the township on sewer issues. We wrote a letter on February 18th of last year to the township requesting an amendment to the wastewater management plan and a sewer allocation. And we did appear at 2 council meetings on March 4 and June 3rd of last year. So, we have been trying. We understand we're going to have to address this, but we don't think it's a proper checklist, completeness type item. And then moving on, the next 5 items are more technical in nature. So, and these have to do with checklist item 11, which is the dimensions and bearings of all lot lines. Item 12, which is setback distances for various features on the plan. Item 27, showing dimensions of proposed sidewalks. Item 38, location of the driveway on lot 6, which I mentioned before. And 45, locations, dimensions, and construction details of solid waste disposal receptacles. I'm going to defer to our engineer, Kyle McKenna, on these.
Kyle on.
He's getting there.
Okay.
He's in the same room, but just, the volume we're trying to.
Right. Okay.
I got now.
All right, can everyone hear me?
Yes.
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 Sorry, can everyone hear me?
Yes, we
Yes.
can.
Yes.
Great, thank you. So as Mr. Peck noted, there are some requests for supplemental dimensions and survey information on the plans that we submitted. We have no objection to providing that information. I think it's really just a matter of just supplemental notations to further detail the setbacks of the various items pointed out. Our zoning and bulk table does provide what we feel is an acceptable level of setback criteria for buildings and the proposed structure on the property, but no objection to during supplemental submission to provide the additional detail provided.
About item 59.
Sure. Yeah. So I guess skipping ahead to item number 59 on the checklist. So with our application, we did submit a preliminary geotechnical investigation, which was inclusive of some geophysical investigation as well. So there was borings, test pits completed, along with an actual a scan of the site for electrical resistivity, which is specific to the known conditions in the area related to limestone and karst topography. We marked that we felt that this was meeting the intent of the checklist criteria. It actually, in our opinion, is a little bit beyond what the standard phase 1 in the ordinance requires. Again, if the board feels that we need to provide this supplemental information in the form of the maps and other items identified in the ordinance, we could provide this, but we did feel it meets the intent of this checklist item as far as completeness in providing data to review the application from a geological and geotechnical perspective.
And Kyle, I'm just going to shout. There's also 3 items that we indicated are not applicable. Items 37, which is the location, size, description of any lands to be dedicated to the township or county. Item 48, delineation of floodways and streams and rivers and such. And item 60, presence of wetlands, if any, in compliance with applicable DEP regulations. Can you explain to the board why these aren't applicable?
Sure. So as far as location, size, and description of any lands to be dedicated to the town or county, none are proposed as far as dedication. So we felt that was not applicable for that particular reason. In review of the available state NJDEP online mapping and GIS, there's no presence of wetlands on or immediately adjacent to the subject site. Again, the same goes with flood hazard area or other environmentally sensitive areas. We've met with the NJDEP Highlands preliminarily. They agree with our interpretation in that regard. And we are, again, concurrent to this application. We have an application into the Highlands that was submitted on December 22nd. They're, as Mr. Peck noted, they're performing their field visit tomorrow. So again, we don't feel that this is applicable to the application or completeness for review, for technical review.
Okay, and Kai, on that, why don't we just move on to the final site plan, which again, the deficiencies are very similar to what we've seen with the preliminary. It's items 26, 52, 54, and 61, which is again setbacks for various features on site, provisions for refuse and garbage disposal on site, emergency lanes and fire zones, and then again, the phase 1. So can you
Sure. So the checklist item number 26, similar to my previous description, supplemental dimensions to various features throughout the site. We can provide that information. The refuse and garbage. So we did provide notation on our plans indicating that refuse and garbage disposal will be handled via trash compactors in the truck loading area. That's the intent. If additional information is needed at this time for the board to review the application, we could provide that. But really the intent was that we would address that during testimony and just note that is the overall plan. Obviously, ultimately dependent upon tenants and things of that nature. Again, just going back to, the emergency fire lane. So we had initially noted waiver for providing emergency fire lanes immediately adjacent to the entirety of the building. That's something we can work through with the board professionals. But again, I think this is just a matter of providing some additional detail and notation as to where the circulation patterns and accommodations for emergency vehicles would be on site. And again, back to item number 61, phase 1 geological study. The intent was that the preliminary geotechnical report that was submitted with the application really does meet the intent of the checklist item and would facilitate a technical review for the application.
Okay, and then the not applicable items on the final detail checklist. Item 42, that's the same as preliminary item 37, dedication to the township or county. That's not going to happen, so that's not applicable. Item 55, present and proposed number of units.
There again, considering the use of the proposed application, we don't feel that that is applicable. There's no proposed residential units. It would be a warehouse or it does type use.
And then finally, item 60, preliminary item 60 that we just spoke about. All right, I'm going to take over now. So therefore, Mr. Chairman, based on the testimony that you just heard, we understand that the Highlands kind of precludes us from getting completeness tonight, and we'll have to ask, that we get that at a subsequent meeting. But for the remainder, and checklist item 59 on the preliminary and 61 on the final, the phase 1, we think we've satisfied that. And the remainder of the checklist items, with the exception of that sewer engineer capacity review, which is, we understand, something we'll have to do in the course of the hearing, but the other checklist items, we would ask for waiver for completeness purposes only.
Oh. Is that the end of your presentation?
That is, thank you.
Thank you. Mr. Bryce, do you have a comment on this?
You're muted, Jim.
Jim, you're muted.
I see that there's not just the board members, but there's a lot of public on here as well. And I'm just going to ask you to put it on mute because I do get a lot of feedback. So if everybody could just mute it to benefit. Just for the benefit of the public and the board, Chairman, just to explain the process and the standards that are generally determined. I think it's important to understand. So everybody.
You're breaking up, Jim.
Yeah, you're breaking up pretty bad.
Can you hear me?
Yes.
I can now, yes.
Can you hear me? Can you pause? Can you quiet your particular? Put yourself on mute. Thank you. I think that was the source of the feedback. Everybody can hear me now?
Yes.
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 All right. So for the benefit of the board and for the public, we'll just review what the purpose of completeness is and the standards that are generally applicable to completeness determinations. I think the board has to understand initially that completeness is what is called for under the municipal land use law, so that an application's decision time starts to commence. So an application for development is filed. The board does not have to actually make a decision for a certain amount of time, and that amount of time is commenced when it is determined that the application is complete. The board has to do a completeness determination for any application that is filed within 45 days of its submission. And clearly we're doing that, where the board's doing that here. I think that it's important to note that the completeness hearing and the completeness process is administrative in nature. It's an administrative process that the board undertakes. So it's not particularly a hearing as you would normally have a hearing where members of the public are allowed to ask questions and cross-examine the witnesses based that the applicant is bringing forward. So when you're looking at Lopatcong zoning ordinance, it's Lopatcong zoning and land use ordinance, and you look at section 243-30, the initial submission is required to be reviewed by your municipal engineer. A report is supposed to be put together, and that report is to be considered by the board in making a completeness determination at a public hearing, which you're doing. It's important to note that section 243-30, both A and B, make it clear that it is the board that determines completeness, not the engineer and no one else. It is the board's mandate to determine completeness. As I indicated, as this is an administrative hearing, it's to be conducted in public, but it's generally not open for public comment and public participation. By your ordinance, section 243-30B, and by custom, the applicant is permitted to appear and of course respond to completeness concerns that are raised by the board. As to completeness determinations, the board is limited in its judgment as to whether the application conforms to the township's submission requirements as set forth in both its ordinance and its checklist. The municipal land use law defines an application as, let me just flip to it because it's important to note. An application for development means the application form, and all accompanying documents required by ordinance for approval of a subdivision, plat, site plan, plan development, cluster development, conditional use, zoning variance, or direction of the issuance of a permit pursuant to section 25 or 27 of the municipal land use law. So when you look at that particular definition, the question is whether or not the application that is submitted is fulsome in its meeting the ordinance and submission requirements as contained within your ordinance. It's important to note that the municipal land use law at section 4055D-10.3 does allow the board the opportunity to grant certain submission waivers upon request of the applicant. In deciding whether to grant such submission waivers, the board is reminded it must act reasonably and not in an arbitrary or capricious manner. In Lopatcong, the township has adopted ordinances that set forth both the checklist and additional submission requirements for applications in order for them to be deemed complete. Usually when the board is reviewing applications for completeness, minor omissions and some minor details can often be waived for submission purposes, but ultimately still required. Usually issues that are jurisdictional, of course, are more concerning. In this particular case, and it has to be noted that the satisfaction of the township's application requirements and checklists is a bit more heightened in the face that there is a recent zoning amendment that did become effective on January 17th. But that effective date was after this particular application was filed. This implicates the time of application rule, which was found at NJSA 40:55D-10.5. And just so the board's aware of what that rule says, I think it's important to note that the law states that notwithstanding any provision of law to the contrary, those development regulations which are in effect on the date of submission of an application for development shall govern the review of that application for development and any decision made with regard to that application for development. Any provisions of an ordinance, except those relating to health and public safety that are adopted subsequent to the date of submission of an application for development, shall not be applicable to that application for development. So that is called the time of application rule. But determination as to whether in this particular case, the filed materials and the forms that were submitted constitute an application for development will directly affect this board's jurisdiction to ultimately determine and listen to this particular application. The leading authority on this point is a case called Dunbar Homes, the zoning board of the Township of Franklin. It's cited at 233 NJ 546, 2018. It's a Supreme Court case. And this case makes it clear that to benefit from the time of application rule, as embedded in NJSA 40:55D-10.5, which I just talked about, an application must contain the required information and documents required by the township's zoning and land use ordinance. Now, I do note that in this particular case, there are multiple requirements within the township code and checklists that are required to be submitted. It is within the board's reasonable discretion whether or not the waivers requested should be granted. The board is not compelled to grant any type of submission waiver, and the board is bound to follow the law that is established in the municipality by ordinance. It simply can't ignore authority that exists. So to that point, and just to Mr. Peck's point, I do note that there was a concern raised as to the sewer issue. And I believe it was an ordinance that was ultimately adopted in September of this year. And I believe it became effective in October. That is a requirement. That requirement doesn't just go away. That did modify the checklist requirements. It was certainly a published ordinance that was on notice. I see it on the website. It was noted on the website as pending legislation and ultimately adopted legislation. It just hasn't been codified yet, but it is on the Township of Lopatcong's website. So that is a checklist item, and it is a checklist detail that just can't be ignored by the board. So with that being said, the board is, I think at this point, tasked with whether or not the submission that was made by the applicant and the materials that they submitted fully comply with the checklist and other submission requirements as detailed by your ordinance and as detailed by both your planner and your engineer. And if it hasn't, whether or not a waiver should be granted by the board for those requirements. Certainly, if you want any further direction as to what the time of application rule is, I'm happy to give that. There is some authority that I think is beneficial to the board. And, you know, certainly in the Dunbar case, it suggests that in order for the benefit of the time of application rule, the applicant must submit the required application documents that are required by ordinance and checklist. In fact, I think that the court there said the standard requires that the zoning officer, or here the board, compare the contents of a submission to the requirements of the municipal ordinance. It does not require a review of each submission to determine whether a meaningful review can be undertaken. It's simply whether it's present or it's not. Certainly the applicant, and I'm just quoting from that case, the applicant's submission will provisionally trigger the time of application rule if a waiver request for one or more items accompanies all required materials. If the board grants the waiver, then the application will be deemed complete. If the board denies the waiver, its decision will be subject to review under the customary arbitrary and capricious or unreasonable standard. So I think that's what I have to advise the board at this point, Chairman, and the public in weighing the completeness of the application that's before it.
Mr. Chairman, may I be heard?
Yes, I'm party. I was muted.
Yes, thank you very much. And certainly, Mr. Bryce, his commentary is noted, and I have had some discussions of the Dunbar case with Mr. Bryce. But I would note that what the Dunbar Homes case, the leading case on the time of application rule, notes is the application for development means the application form, which we submitted, and all accompanying documents required by ordinance for approval of this site plan. We've submitted all of the accompanying documents, going through them. The Highlands consistency determination, by the terms, we have no control over an outside agency. They won't accept our consistency determination application until we filed this application. We have no control over their schedule. They're coming on site tomorrow. I think well, we'll see how it's interpreted, but I think it's a stretch. When you look at what the court rejected in Dunbar Homes, that was the case where the applicant didn't submit a survey, didn't submit stormwater calculations, basically didn't submit anything other than the application form. Here, we've submitted to the board our application to the Highlands for this contingency determination. So if I may finish, I'm just suggesting that we've done everything that is within our power with regards to the Highlands consistency determination, and we will in fact have that determination within the next couple of weeks. They've granted it for they've indicated they're going to grant it before, we just don't have the piece of paper. So that's the first item. The second item is this sewer, the sewer report per ordinance 2020-09, which became effective only in October. Now, Mr. Bryce claims it was on the website. I take his word for it that it was, but I'm pretty familiar with the Lopatcong website. I'm there several times a week, unfortunately, and I was there multiple times in the past week or two in connection with this application. I couldn't find it. And I think it's very unreasonable. And I don't envy Mr. Bryce having to argue this to Judge Miller or whoever hears it to claim that this actually is a checklist item, when in fact it doesn't appear on the checklist. It doesn't appear on the code. When you go to the Lopatcong website and go to the ordinance code book, it's not there.
Mr. Peck, sorry to interrupt, just to provide some clarification. If you go to chapter 243 on the electronic code book, that ordinance 2020-09 does appear on the electronic code, on the township's official electronic land use zoning and land use code.
Okay, well, I went into the E-code again this afternoon and I couldn't find it. And I pulled up 243-43 and it ended at E.
If I could interrupt, this is Joe Pryor. I have it in front of me now. It's been there since I've been looking at this application. It's there. Maybe you didn't look in the wrong place.
Well, I
Mr.
looked
Bryce
where
noted it was advertised. So those
okay,
are the
well,
facts.
clearly, we have a difference of opinion here. But I think that the checklist is supposed to put the public and the applicants on notice of what's required. It doesn't require an applicant to go on a detective hunt to read through the minutes of the past however many years meetings to see if perhaps an ordinance was introduced. It's really patently unreasonable. And again, this board is charged to not act in an arbitrary, capricious, and unreasonable manner. And in this case, relating to this sewer issue, we've already indicated that it's perfectly valid for the board to request this information of us as the applicant in the course of the hearing. But to deem this a completeness item, I think you're completely off base. And I don't think that there's a court in this state that will see it the way that Mr. Bryce is indicating. Now,
Well,
as for checklist items,
the board will make that decision, but you're just wrong when you say it's not on the website and you look today because it's there.
well, I'll look again, and you may have the code in separate spots. But if you go, I'm picturing it right now, the left-hand column of your home page, you go down where it says ordinance code book, click on it, go to the table of contents, go down to chapter 243, pull up section 43, and you'll see it ends at E. At least that's what I've seen the last half dozen times I've gone to the website. But regardless, moving on to checklist items 11, 12, 27, 38, and 45, those have to do with very minor discrepancies on the site plan, which was filed. So again, under the application for development as set forth in the land use law and also in Dunbar Homes, an application development is the application form and all accompanying documents required by ordinance. We submitted the documents required by ordinance. We're not required to make sure that checklist items 11, 12, 27, 38, and 45 are necessarily there. And finally, checklist item 59, as Mr. McKenna testified, we have in fact submitted that. So again, I submit to the board that with regards to the preliminary site plan application, we're not incomplete. That what we have.
Mr. Peck, I'd like to speak to the geotechnical study. The study was a preliminary geotechnical study prepared at the time a preliminary concept plan was prepared and presented or being prepared by the engineering firm Bowler, with where Mr. McKenna is working. So that study was prepared on a preliminary basis, and based on our preliminary review as part of completeness, it does not meet the ordinance requirements outlined for the geotechnical study for projects being developed in areas of limestone and karst topography. So there will be, and this report prepared by Whitestone Associates does have a kind of a clarification and or I don't know what the term would be, but a disclaimer saying that a final concept plan has not been prepared, and this is a preliminary study of the site. So the study needs to be prepared based on the plan being presented to the board, indicating, the ultimate earthwork and different other geotechnical items that'll have to be done on the site. So there is additional work needed in order to make this report consistent with the submission requirements.
Okay, but that again comes back to the board being charged to act in a reasonable manner. And, these waivers for completeness purposes only, these very few waivers for completeness purposes only, which are routinely granted in the course of really any land use application, I would just submit that these few items are customarily and ordinarily given completeness waivers for. So we'll leave it at that. And again, while I'm talking to you, I pulled up the municipal website again, and I'm looking at your code book right now, and homepage, left-hand side, ordinance book 243-43 ends at E. So if you're expecting the public or any applicant to have any notice of this requirement to have a sewer capacity review, you're mistaken. How's anyone going to know? It's not in the code book, and it's not on your checklist.
Mr. Peck, all due respect to your legal position, that's fine, except that this is an ordinance. The ordinance was adopted by the municipality. The board is not in a position to overlook the ordinance. It's unfortunate that certain applicants have not done a due diligence search of pending and a newly adopted legislation.
It's not in the new ordinances, Mr. Bryce. It's
Gentlemen,
not there.
gentlemen,
Mr.
please.
Peck, let me be very clear. What is provided online is a courtesy. It is not the law in and of itself. That's why the municipal clerk has the adopted ordinance books that are available for public inspection. That is why ordinances are not only noticed for a public hearing.
How can we inspect the ordinance book when the municipal building's closed?
Gentlemen,
Let me in
gentlemen,
tonight.
please.
I'm not through, Mr. Peck. It's also why they are published. So do not say for 1 second that this ordinance is not effective to this board, because it is, and this board has the jurisdiction whether or not to waive the submission requirement at this time. It is the board. And let me be more specific, Mr. Peck. The completeness, as indicated in Dunbar Homes, isn't the dispositive issue for your time of application rule. The time of application rule is whether or not when you submitted it, it was actually fulfilled and complete. From the technical perspective, completeness has nothing to do with it, as per the Dunbar Homes. So, we can start dickering back and forth, but at the end of the day, it is this board's determination as to whether or not this application is complete and contains all of the materials and information as required by the ordinance and the checklist itself. Period. And if it is not inclined to grant a submission waiver, and it is arguable, if not mandatory, that when it comes to the Highlands area consistency determination, that is not waivable, it is therefore incomplete. That is the board's determination, not mine and not yours.
That's all understood, but again, I just renew my objection to deeming the item from ordinance 2020-09 to be a checklist item. I understand that the ordinance was adopted. I'm not challenging its validity. What I am challenging is how it can be imposed on an applicant when no reasonable person, and I hear what you're saying, it's incumbent on us to check all the legal notices and all that. I get it. But you say it's there in the clerk's office for public inspection. Guess what? I showed up at the municipal building this evening, wouldn't let me in. So again, if it's not on the website, whatever, I've made the argument. I think that there's very few waivers for completeness purposes only that we're requesting. And I would request that. And again, we have no objection to providing the information required by ordinance 2020-09. We just think it's completely unreasonable and unjust to require it as a checklist item. Thank you.
Adam, do you have any comments on your report here? Have you go through it for the board?
I mean, Mr. Peck went through it, and as did Mr. McKenna. I mean, some of these items typically, would be items that we would also list in a technical review. So those additional dimensions we're requesting, and those would speak to handicap accessibility, dimensioning of sidewalks and things of that nature, as well as showing where certain disposable receptacles would be located, if they're trash compactors, or if a dumpster might be constructed one day, and how that would be screened. Those things can obviously change as the site is developed and an ultimate tenant is selected. But I believe those certain items that unfortunately we're kind of rehashing here are those items that would make the application incomplete. And those other items within non-applicability, I have no objection to the discussion regarding dedication of land to the township or county. That's not being considered with this application, so that would be non-applicable. And regarding floodplains, floodways, and wetlands, I would agree. I didn't see anything on any mapping software that I've reviewed that's publicly available that would indicate any of those features being on the site.
All right, Adam, I'd like to interrupt you right there because I object to that.
Sure.
The creek runs by the site. It's very easy to get a presence or absence determination. There's no reason. I mean, here they're putting, they're not applicable. That's an easy thing to get. You get a clean site. If there are wetlands there adjacent to the stream, they get delineated, and we all know that. So I'll just put my 2 cents in there.
Thank you, Adam. Are you
Okay.
complete or?
That, I mean, really, I think we went through the completeness items are really focused on that, the sewer approval, the Highlands consistency, obviously, and then also the geotechnical study being completed in accordance with the ordinance.
Thank you. George, do you have any comments?
There. I'm sorry. Took a while to figure out what button to push. No, not in terms of completeness. My review is, as we have always provided to the applicant and the board, is a review of the various variances and design waivers that are associated with their current submission. The only comment, and I can't really add anything to it, was Adam's comment, and in terms of that applications for development shall not be deemed complete or considered for review until the board has in its hands a Highlands determination. That's the only thing that's noted in my review, the same as in Adam's, as a potential completeness item. The rest of mine is to inform the applicant and the board as to what design variances and waivers would be requested as we proceed.
Thank you. Do any of the board members have additional questions of our professionals or comments they'd like to make?
I'd just like to go back to the sewer for a second. It's correct, Mr. Peck did come before council. He was looking for a wastewater management plan amendment. his applicant knew, and we're under no obligation to do that. The wastewater management plan is a planning tool. It's incorporated as part of the Highlands right now. The applicant knew sewer would be an issue. I'll just add that.
Thank you.
Mr. Chairman,
My
Mr. Chairman,
biggest
Paul
concern-
Sturbins. I just wanted to augment what Adam discussed before about the geotechnical report. The reason why Adam and I flagged that item is not being addressed had to do with the phase one investigation, which is in the ordinance. The phase one investigation is supposed to be a high-level review of subsurface conditions, not only on the site, but also within a quarter mile of the site. And that information was not provided in the report. Yes, there's information in the report that is probably more related to a phase two investigation, which is also discussed in the ordinance. But there was nothing in the report that led us to believe that the phase one investigation was done. And that's why we made that determination in both the preliminary major site plan checklist review, as well as the final major site plan checklist review. So thank you.
Thank you. My major concerns, basically where we're going down here is top on the list is the Highlands Council's requirement that we have to have a approval of the consistency determination by them before we take any action. And it's, our ordinance indicates that we do not have the authority to waive that until that is completed. We don't have a consistency determination for this project yet. I don't have a crystal ball to figure out what they're going to be doing there. So and we have in the past not determined or have determined that it's inconsistent for the checklist without that determination. And that's one of my major problems here. The other thing is the sewer capacity. The ordinance was put in because of the fact that we're running short of sewer capacity in the township, and we wanted to try to figure out, you know, what we could do and what we can't do. Without that, we're not going forward. So at this point, I would think that we would probably determine that this application is incomplete at this time. You know, they're welcome to come back and submit another application if they want, but that's my feeling on this now. So without any further comments from anyone, I'm opening it up to the board members and the professionals, the applicant. Hearing none of those, we'll move to a determination. Thank you. Is there anyone want to have a comment? Pardon?
Do you want a motion? Or is that what you're asking?
If everyone has had their say, I'm going to have a motion that we deem it incomplete. You made a motion on that, Joe?
Well, or did you? I will make that motion if it's not on the floor yet.
Okay, do I have a second?
Second.
Okay, Beth, roll call.
Who was the second, please?
Robert Sampson.
Thank you. Okay. Members Clymer,
I have a question. You were breaking up. What is it for? Incomplete?
Oh, yes, vote is for incomplete, yes.
Okay, my vote is yes.
Coyle,
Muted. You're muted. Hang on.
yes. Fryer,
Yes,
Sampson,
Yes.
Weeks,
Yes.
Mayor Mengucci,
Yes.
Vice Chairman Fishback,
Yes.
Chairman Van Vliet.
Yes. Mr. Beck, we're sorry,
Yep.
but it's been deemed incomplete. You're welcome to come back without prejudice, so
Thank you very much. We'll be figuring out our next steps. Have a good
Okay, thank you very much.
day.
Okay, we now move on to the application of bridge construction for, again, another warehouse on Strikers Road.
Thank you.
I lost
Mr.
most of my
Chairman?
papers here. Yes, that's block 99, lot 6 subdivision, site plan completeness. Is the applicant here?
Mr. Chairman, this is Arvin Ital, I'm an attorney. I represent the applicant. Can you hear me?
You're breaking up.
Yeah. Unfortunately, Zoom booted me off of it, even though it was probably the 5th or 6th person on today. I cannot re-log on. I've had to call in, and I have probably the worst connection possible on a network that's providing me 4 bars. So I can only say that it's probably not on my end. It sounds as though it's a very difficult endeavor for the members of the board there this evening. I hope you can hear me. And if at some point maybe I should just say a few words at a time and just confirm that I'm still being heard.
You are being heard at this point.
Thank you very much. Mr. Chairman, what I'd like to start off is after the dialogue and the analysis that your attorney was able to provide the board, add one little bit that I want the board to also consider. And that is many of the comments that we have in the review letters that we're going to be going over, and I have Brett Skapanis, our engineer with Dynamic, to go over some of the technical details. But in terms of the law, I want the board to keep in mind that there are qualitative versus quantitative issues in determining completeness. And in 1979, the state of the law in New Jersey was to look at essentially how many items were missing, the quantitative. And if you're missing them, well, sorry, then you're incomplete. The law in New Jersey and the cases have changed to analyze this in a more logical fashion by looking at the qualitative issues. Now, there are 63 items the last I checked on your checklist. There are also an additional 33 that you can find under your zoning ordinance in section 243-43. Those 99 or so items make up what we would say are the items that are your checklist type items. I will echo in on an issue that you have opined about, but to second what Mr. Peck has been saying, I've been looking also for ordinance 2020-09. And I'll tell you, ordinance code 360 does not have reference to it. I'm sure that it exists. Everyone says this about everyone else's website, that it's not the most logically laid out. So I'm not denying that it exists someplace. But in terms of whether there is a fairness issue in finding that ordinance and it's readily available, I can tell you that Mr. Peck was, I'm sure, very diligent in looking for it. And I can only speak for myself, saying that I was diligent in looking for it, including while we were on hold. I had difficulty finding it as well. But in terms of the review letters, we have that same comment that we have to comply with section 243-43F of the land use ordinance, which was codified by ordinance 20. That's the codification of ordinance 2020-09. We have, in fact, already requested the sanitary sewer capacity review from Mazer prior to our submission, and there's a correspondence that we provided. So I think that we've complied substantially with that. Again, this is a qualitative rather than the quantitative analysis that this board has to have. There are a number of other checklist items, and I'd like our engineer, Brett, if you're on the line, if you could unmute yourself, I'd like to walk you through that if we could do that.
Yep, not a problem. I'm here. I will.
Great. So we have the same issue as was the board just heard about, checklist item 62.
Yes.
And that is the Highlands site being actually looked at. It's scheduled to be looked at tomorrow. And I don't want to overstate this, Brett, so tell me if I'm incorrect in how I'm characterizing this. We need to submit an application to get the Highlands folks out here to look and to do a determination. And we can't do that until that application's been filed.
That's correct.
So they're coming out as quickly as they can. We don't control when you schedule your board meetings to have these reviews. It's going to be done tomorrow. So let me start off by saying, if the board's determination tonight is you're incomplete because you didn't have the Highlands checklist item 62 taken care of from the Highlands Council, then I would ask your board attorney to opine whether this is in fact the appropriate time for me to ask you to carry this until next meeting.
This is a completeness determination at this point in time. And certainly your application, you can ask it to be carried. I don't know if that is going to have any effect. And really, let's get to the heart of it. The time of application rule is whether it was complete when it was actually submitted.
Right. I'm not much into gamesmanship. What I am into is making sure that fairness prevails. And that is, we have absolutely, as the applicant, absolutely no say in determining when these meetings are scheduled and when you're going to schedule us for a completeness review before a hearing. We can't file the applications with the Highlands Council until application has been filed with the municipality. That's been done. You've scheduled an application review for completeness at a time the day prior to the Highlands Council actually walking the site to make that determination. And I'm going to go back to, is this a qualitative or a quantitative item? I know that you're going to say, look, we can't waive it because we don't have the authority to waive it. What you do have is the authority to say, well, we're not going to waive that requirement, but without that, you're not going to get a hearing. The application itself, again, quality over quantity, is that we have to make that application. We've done that. Brett, I'd like you to cover checklist item 62. Go through the items that we've actually undertaken, the steps that we've undertaken to comply with item 62.
Well, 62 is that Highlands consistency determination request, and we have made the application to Highlands. We did it concurrently with making the application to the town, getting that in the door so that they could perform their review. And as you noted, we do have the scheduled meeting with them tomorrow morning to walk through as their initial step to, on their end, they typically perform the site visit in compiling their information to then issue that determination.
Right. Now, I'd also discussed a checklist item, well, it's actually an ordinance item and under ordinance 2020-09. And I don't want to open up that can of worms again about whether it's, a checklist item or not, but tell us what we've done in terms of compliance with that.
Right, and I know I was listening in on the previous application, and there was talk about capacity and a wastewater management plan, whether that property, I guess, has sewer or not. This property is in the sewer service area. We did our due diligence, understanding Lopatcong is served by the town of Phillipsburg treatment plant. We spoke to Remington and Vernick, the engineer for the plant, obtained data from them, understanding that there is available capacity in Lopatcong, but we do understand that that's dwindling. Heard the comment earlier about that, I believe, from the chairman. But we do know that there is available capacity for this project currently today, based on that information. Ahead of the application, we did make our request to Maser Consulting. We put it in writing. It was a request. We did get a response back indicating that they would work on a letter for us and have not received that to date.
Okay, and we don't have that in our control to get that letter out because that is in fact the consulting firm, the consulting engineers for the municipality, correct?
Yes.
Okay, so I would characterize this as compliance, would you not? That we've done what we can to get the township to provide the information to the board.
We did everything to, yeah, that we can under our power to be able to request that item to make that checklist item complete.
Okay. Mr. Chairman, as to that, and I would like, if the board would bifurcate each one of these issues, I would like them to bifurcate each one of these issues and make a determination as to whether they believe that this item is in fact disqualifying for us to have our application deemed complete, separate and apart from every other. I would rather not have this board say, well, you've got 8 items, so as a whole, we're going to count 8 as being not quantitatively, I should say, sufficient to say that you're not complete. I want this board to look at these on a quantitative basis. So I would ask the chair at this point to have his board make a determination as to whether that item we are in compliance.
I understand, counsel, that you'd like to direct the board how to conduct its business, but that's up to the chair. There's some discussion about meaningful review versus quantitative, qualitative. And I think that you have to really look at the Dunbar case because what the Supreme Court there was critical of was the trial court judge's concern with looking to see whether or not the material submitted would have provided the board with meaningful review. And he determined for the time of application rule benefit in any event, that was what was submitted was enough for a meaningful review. That was wholly discounted and rejected by the Supreme Court. Again, the court looked to the information and the documents required in the ordinance and checklist. The court there, Justice Solomon said that clear, easily applied and objective standard advances the MLUL's goal of statewide consistency and uniformity in land use divisions. I'm going to omit the site. It says the standard requires that the zoning officer compare the contents of submission to the requirements of the municipal ordinance. It does not require review of each submission to determine whether a meaningful review can be undertaken. The trial court outlined a standard for requiring enough information so that at least the township can get started on engaging a meaningful review, and concluded that the board's rejection of the application was arbitrary and capricious because the township was able to functionally begin a review on the date of the application submission. We agree with the appellate division that the trial court standard is fatally imprecise and inconsistent with the legislature's intent that the municipal land use law bring consistency, statewide uniformity, and predictability to the approval process. Once again, I'm going to omit citations, but the entire point is that we're not looking at qualitative, we are looking at quantitative, whether things are there, present or not, as required by the ordinance. Whether a submission waiver can be granted is within the board's discretion. And how the board wishes to treat its completeness review, I think is up to the board with all due respect to your specific request.
I understand. I'm not trying to usurp the powers of the chair. Please don't misunderstand that. And I certainly didn't mean that. What I am suggesting is to the chair that he look at each one of these individually. I would ask the chair to consider making a finding on this specific issue, whether the chair believes and the board believes that this item itself is sufficient in and of itself to deem our application incomplete.
Which ordinance checklist item are you referring to?
This would be it's actually not a checklist item. It is under ordinance 2020-09, and that requires a review issued by the township's sewer engineer indicating that there's sufficient capacity. As our engineer has indicated, we've made that request, and that request resides, the answer that the board needs to have does not reside with us. It is entirely within the control of the consulting engineer for the township.
Hey, Mr. Chairman, I'm going to jump in. This is Paul Sturbins, the township engineer. And just to clarify, Mr. Skapanitz and his firm did request a will serve letter from me. I was not going to issue a will serve letter because I'm not the township sewer engineer. Mr. Madden is the sewer. And 2000, there's a process here for establishing capacity through the planning board submission process. So I didn't respond to that particular request because there's a process for determining capacity. It's not through me.
So
Brett,
I'll
can you
ask you,
clarify?
did you make an application to our sewer engineer?
Right. Let me just have you jump in if you wouldn't mind. That initial request that we had.
Right, we did not, we made that request to Mr. Sturbins for the will serve letter to understand that whether or not sewer was available for the property, and we
He's
understand.
not the person that
Which is
determines
a
that,
typical
though.
Excuse me?
He's not the person that determines that. That's our sewer engineer that would do that.
Okay,
And actually, Mr. Chairman, we never issued will serve letters.
okay, well, that.
Okay,
Chairman, may I-
but it still remains that it didn't go to the proper person to
That's
do that.
correct, but that
Okay.
comes down the road. The analysis, as you know, is a rather complicated one.
Correct.
It's not as simple as a will serve letter.
Okay, then that analysis.
So
we
you
did
haven't
not-
completed that then.
Well, let me point out to the board that the checklist items that you're referring to as checklist items require us to submit this to the township for their opinion. If there's a process for it and it's not in that ordinance, I'm not sure how this board can determine that we're incomplete because we didn't follow a procedure that's not in the ordinance that it's relying upon to say is a checklist item.
I'm not here to make that determination. That would be above my pay grade.
And with all due respect, what we're saying is that the process itself is in the control of the township. We have, in fact, submitted an application that complies with the requirements. We do know that we do have, and certainly you can consult with your engineer, that there is in fact capacity here. So our situation is one that the board can comfortably make a determination that it is ready to proceed, and that further analysis, if it turns, it will result in a report from your consulting engineer indicating that that is in fact the case.
I'm not going to argue the point with you there. I'm not a lawyer. I'm, an engineer, and I don't see where you're coming from. You didn't go to the right person. We don't have that information, and that's the information we're looking for. So, as a planning board. I'll defer to Mr. Bryce on this one to get advice on this.
I mean, Chairman, I mean, that's one issue of several. You got several checklist items that are just simply missing. Checklist item 62, the sewer, regardless, even if you assume that the sewer is not even applicable, there's lacking minimum setback distances for features along Strikage Road frontage. Sidewalk dimensions not provided for parking areas. More importantly, I think the location of driveways within 100 feet of the site, including those under construction on Strikers Road, which is a checklist requirement that's very clear, and that information should have been provided. It does not depict a 50-foot wide access and utility easement. Again, driveways within 100 feet. Preliminary architectural plans were not provided for at least the proposed parking garage. And I guess an LOI for boundaries of the freshwater wetlands shown on the plan, which was also required as per our checklist. They do indicate that the location, size, and description of lands to be dedicated is not applicable, and I'd assume that to be true. So, there's more than a handful of items of information that were not provided with the the material submitted.
So I'll have our engineer go through each of these. I really was focusing on ordinance 2020-09 for the moment.
Right, and I'm prepared to go through each one of these. Mr. Bryce, you know, just to run through the list from Mr. Sturban's letter of July 22nd, the January 22nd, the checklist item number 12, minimum distances with respect to features along the frontage. We have detail. We need to provide some additional detail, but we had provided some in the plan. So that's I guess a minor addition to the plans for clarification, but I believe we meant the intent. Sidewalk dimensions, we have a lot of sidewalk throughout and we need to add additional dimensions to the plan. I believe it's the same with 12. Number 28, we do have a detail in our plans that calls out the size of parking stalls. We do have a call out in our chart, parking chart, that says 9 by 18 stalls. We just need to provide the additional dimensions and some additional locations on the plan. So I do believe we met the intent of checklist item number 28, but we'll certainly provide the additional detail. Driveways within 100 feet of the site. We do have an aerial plan. We are showing the driveways that are in closest proximity based on our survey. We believe we're covering all those within 100 feet between those two sheets, but certainly we can provide additional clarification, including the driveway that's proposed for across the street. We know from us that is under construction. I believe that's just really providing some additional technical clarification, but again, believe that we meet the intent of the checklist item. Number 36, we need to provide an access and utility easement for sure. Again, that's an item that we can easily provide in the plan. The other one, last one would be, again, because there's a repeat, 38, same thing about the driveways within 100 feet of the site, as I noted, is similar to this item number 30. With respect to the architectural plans and elevations, we did submit preliminary elevations and floor plans for the buildings. This project does propose parking decks, so we did not provide the specific detail there. And while we're on this item, first and foremost, we will provide the elevations of the decks. What we do, I do also note with respect to the application here, and this was called out in Mr. Ritter's letter, and this will clarify the item brought up in Mr. Ritter's letter with regards to the deck being used as FAR in our application, as well as the height of the deck. We fully intend to comply with the accessory height of 40 feet and will stand by the fact that the deck area does not count as floor area ratio with respect to your ordinances. But in speaking with Mr. Sturbins separately, when we received his letter, we do note that he needs the clarification of that elevation, which we will provide to the board and to his office.
Oh,
okay. And checklist item 60, did you touch upon that as well? I'm sorry, I was breaking up.
Checklist item number 60. Yeah, actually, you know what? I didn't. And checklist item number 60, as it's written in Mr. Sturbin's letter, is talking about a letter of interpretation, verifying the boundaries of freshwater wetlands. We do show freshwater wetlands on our plan. We do know that downhill from our site towards Lopatcong Creek, there is our wetlands associated with that, and they were flagged, surveyed, and they are noted on our plan. We are filing for an LOI, but that process, similar to Highlands, takes time. And I think the board is probably well aware of applications, which I'm sure have come across it, that involve wetlands and obtaining an LOI from the state of New Jersey. And of course, that does take time for them to review. But when I do read your checklist for preliminary under that item notes the presence of wetlands, if any, and compliance with applicable NJDEP regulations. We're showing the presence of wetlands. We do know that they are there. We have them flagged. Compliance with DEP regulations is going to come once we get the LOI, that line is verified, and we can make the appropriate application to the DEP as a result of their determination as to the type and location of the wetlands that we've indicated in our plan. So that's part of the process. So I do believe we meet checklist item number 60 by showing the wetlands in our submission set.
So, Mr. Chairman, at this time, what I'd like to ask is, as your attorneys advised you already, you have 45 days to act from the date that an application is filed, make a determination of completeness. And that 45 days is there not only for the benefit of the municipality, but also for the benefit of the applicant. This application was filed in December 23rd, I believe, is the date, well, within the 45-day period. I don't know when your next planning board meeting is, but the applicant is prepared to grant an extension of time for the completeness review. We would like that opportunity to further address this as we believe that there are items that will be met without a determination by this board tonight as to completeness or incompleteness, but that will be met, which are outside of our control. So I'd first like to ask the chair to entertain my request to carry this to the next planning board hearing with an extension of time being granted by the applicant.
Chairman, the board is, the application right now is before completeness, whether or not it's complete now or complete later. Certainly they're not prohibited from submitting additional documents into the future for a continuation of the completeness. The board is, I think, empowered to make a completeness determination as to the materials that have been submitted this far. And you're acting within your statutory timeframe to do so. I would note for that there may be certain things that the board are willing to waive. I leave that to the board's discretion, some of the LOI things that were mentioned. Again, the board has the opportunity to grant a submission waiver. There was something that was brought up by the applicant's engineer, though, that is concerning, which is regarding the FAR, which calls into question the board's jurisdiction over this entire application. Council, do you want to be heard on that?
The engineer indicated that both the FAR, and I think that's a strict interpretation, and I think of the ordinance that I believe you should be making, which is whether the floor area of the garage is counted for purposes of the site FAR, and if we exceed the FAR with the garage, whether that in fact triggers a D variance. I do not believe that it does. Our engineers also indicated that he does not believe that it does either. And I think in an abundance of caution, this board, which may not have jurisdiction, but I would say that it probably does, should probably research that issue and not make a decision tonight as to completeness.
Well, I think that the board right now has the benefit of its planners and engineers review. From my understanding, while our local ordinance does define floor area for both net and for gross, our local ordinance does not define FAR or floor area ratio. It just kind of states what the floor area is. I note that in section NJSA 40:55-70, D4, it says, in particular cases for special reasons, and this is for the zoning board's jurisdiction under section 20, increase in the permitted floor area ratio as defined in section 3.1 of PL 1975, chapter 291, which is 4055D-4. And if you look at what the definition of floor area ratio is there, as required under the land use law, it's defined as, let me just get to it. Floor area ratio means the sum of the area of all floors of buildings or structures compared to the total area of land that is the subject of an application for development, including non-contiguous land if authorized by municipal ordinance or by plan development. So the question, I think that when you're looking at it, and if I understood our engineer and planners review, is that the warehouse is a building and the parking garage is a structure, and under the municipal land use law, all of that goes into floor area ratio by definition, and it exceeds what's permitted in the ordinance. So I don't know how I don't know how the board can even assume jurisdiction if a D4 variance is required. And I would suggest that if a D4 variance is required, as indicated, you're in front of the wrong board. And I think that the board would frankly lack jurisdiction based upon FAR.
Mr. Bryce, I do want to point out, I think you noted earlier that there was no definition in your ordinance. But if I can point you to section 243-5 in your definitions for gross floor area, it specifies, and I'll read it, the sum of the gross horizontal areas of the floor or floors of a building, whether used for occupancy, business, or storage. Said areas shall be measured between the outside face of exterior walls or from the center line of walls separating two uses. Said areas shall include usable areas below the level of the adjoining ground, garage space, accessory building space. That there says to me that the garage is not a building, floors of a building used for occupancy or business or storage. And even further clarifies, talking about how areas below a garage space would qualify. To go on further, your building definition, then if it does go to gross floor area, it's floors of a building, whereas your definition of building under that same section calls out that it's a structure constructed or erected on the ground with a roof supported by columns or walls. The term building shall be construed as if followed by the words or part thereof. And we do not have this is not a structure that has a roof. So
But it does have a roof and it has columns that support floors, right?
It's four.
It does not have a roof.
Excuse me?
It does not have a roof.
Right, correct.
You're parking on the roof. It's a parking deck, right? You're parking cars on the roof.
It's not a roof.
It's a floor.
No.
Yeah,
and
it's a stretch. I can't, I've never.
A way of measuring it, that's fine. However, it still exists that you exceed the floor area ratio.
Without the garage, that is not.
You would have to ask for a use variance on that, and we're not empowered to grant that.
Yeah, and Chairman, if I may, Chairman, I'm looking at the floor area gross as defined in our ordinance at 5. And it says the sum of the gross horizontal areas of the floor or floors of a building, whether used for occupancy, business, or storage, said area shall be measured between the outside face of exterior walls or from the center line of walls separated uses. Then it goes on, and this is important. It says said area shall include usable areas below the level of the adjoining ground, garage space, or accessory building space. It seems to be an inclusive definition when it comes to floor area gross. But I still don't believe that that is what the standard is when it comes to this particular parking garage. Because what is clear in the municipal land use law, and as I indicated, while our ordinance would define floor area gross and separate that from floor area net or floor area livable, what is clear and what distinguishes this from the building argument is that section 40:55D, I think it is is 4, which I just stated,
Yes.
define floor area ratio as not just the building, but also structure.
Mhm.
And certainly a parking garage is a structure under both our ordinance and the municipal land use law. And the section under 70, which is section 70D4, references the actual definition provided in the municipal land use law for FAR, which includes structure. So it looks to be as if it is a FAR issue when you're exceeding what our permitted FAR is. Because it says clearly floor area ratio means the sum of the area of all floors of buildings or structures. So it includes structures, and structures are defined as a combination of material, form, and construction for occupancy, use, or ornament, whether installed on, above, or below the surface of a parcel of land. So I think that under the very requirements as provided for in the municipal land use law specifically, a FAR of 37% is in excess of what we're allowed under the ordinance, and a D variance would be required, and this board does not have jurisdiction over D variances.
So let me stop for just 1 second. This is Arvin Itel again, the attorney for the applicant. So my question is this: if we're all in agreement that the municipal land use law has a definition for floor area, and what we're not in agreement with is what, and the municipal land use law also defers to the municipality to provide the definitions for what would be considered to be what's authorized, I should say, by the municipal ordinance to be counted among the floor areas for the buildings. The local ordinance does in fact require a roof of a structure in order to be considered a building. So I'm not sure whether this board is in a position to opine on the spot. I'm a little disappointed because this was in fact an issue that we believed was clear from the ordinance itself, and we're substantially prejudiced because here we are at the hearing. The ship has already sailed as to whether this board has taken jurisdiction of this application. And here we are in the middle of having a discussion about completeness of the application. And lo and behold, something that was called out by your professional that we brought up suddenly raises the eyebrows of the board members to start scrambling through your ordinance to look for the definition. I think that the prudent thing to do at this point is that it's not a question of whether we, the applicant, are ready to proceed today, but it appears that the township is not ready to proceed to opine about the completeness of this application, because it is yet to make a determination as to whether it even has jurisdiction.
And Counselor, I appreciate that, except you know what? It was in the review memoranda that was provided both to you and to the board, and it is the board that makes the determination as to jurisdiction. It is not Mr. Ritter. It is not Mr. Sturbins. It is not myself, although that we will guide the board. I will say this. I think that it has not just been brought to your attention in advance, an issue of jurisdiction. The only time that it can be brought is in a public hearing before the board. It would be improper for Mr. Ritter to have just said, we're not hearing you because we think that we lack jurisdiction. I think that the question is squarely before the board. The board has the ability, inherent ability, to interpret its jurisdiction. In fact, there's case law, if it learns throughout the course of a hearing it lacks jurisdiction, the board must then deny the application for lack of jurisdiction. It's still empowered to always determine its jurisdiction. So whether you're offended or not, I apologize. It's not really the board's concern at this point. The fact of the matter is that when you look at what the municipal land use law says, which, as I referenced at section 4055D-70D4, and cross-reference as specifically made by the municipal land use law, where it defines floor area ratio, where it clearly says it's the sum of all floors, buildings, or structures. The township doesn't even have to say anything. compared to the total area of land that is subject of an application for development. That seems fairly clear to me that that's a D, and it's just my opinion of the board, seems fairly clear to me that that's a D4 variance. And frankly, to suggest that a parking structure is somehow, doesn't have a roof. I mean, does it have gutters? I would assume that it
Well,
does.
I'm gonna defer to your ordinance because the municipal land use law does. It defers to the ordinance.
No, the municipal land use law actually defines FAR. The
And
municipal
it defines it to include what the ordinance of the municipality defines.
No, it actually defines, as I indicated, FAR actually defines how it's measured and what it is. And it includes not just buildings, but structures. That's the
If
municipal.
authorized by municipal ordinance or by a plan development.
That's as related, and that modifies contiguous property as may be allowed. So let's not try to use that modification to somehow twist the meaning of that statute.
Understood. So this board would retain jurisdiction without that parking deck. So I would withdraw the parking deck from the plans.
I don't
That's
think
not, you made that application. At this point, since our jurisdiction is in question, I think there's enough checklist items that have not been completed, and I specifically referenced checklist item 62, where we can't waive the completion determination by the Highlands, that I would think that we should deem this application incomplete, and then we'll determine the jurisdiction of whether we have jurisdiction over this or not. Is that a reasonable approach, Mr. Bryce?
Yeah, I think that you can do a two-phase process on this, Chairman. You can determine completeness just for the benefit of the applicant, just so that the record is clear. But I do think that the board should make the determination based upon Mr. Ritter's review, Mr. Sturban's review, the application itself, the municipal land use law, and my opinion that it lacks jurisdiction over this application. And for that reason would deny the application without prejudice for lack of jurisdiction.
Can we combine those two, deeming it incomplete and indicating that we have a lack of jurisdiction on this in one motion, or do you want to break it up?
You can do it either way, Chairman. That's however the member wants to make a motion.
Any further comment by the board members? How about our professionals? Any further comment?
Yeah.
Hearing none.
No.
Pardon, George, go ahead.
Oh, no, I've said we've covered the issue. I'm fine.
Okay. In that case, I propose a motion that we deem the application incomplete and determine that we don't have jurisdiction over this as the application is presented. Do I hear a motion on that?
I'll make that motion.
Do I hear a second?
I'll second it.
Beth, can we have a roll call, please? Beth, are you there?
I'm here. You hear me?
Yes.
Member Coyle,
Yes.
Member Pryor,
Yes.
Member Sampson,
Yes.
Member Weeks,
Yes.
Mayor Mengucci,
Yes.
Vice Chairman Fishback,
Yes.
Chairman Van Vliet.
Yes.
Hey, Beth, did you call me?
I did. Did you answer?
I didn't hear it, no. So my answer is yes.
Thank you.
Okay, motion carries. The application is deemed incomplete and the planning board doesn't have jurisdiction as the application was presented. So without prejudice, you're free to reapply, coming in with the proper information. Thank you.
Thank you, Mr. Chairman.
Thank you. Okay, I'm lost my minutes here, so hold on a second.
Chairman, you're up to public comment.
Public comment. Okay. Thank you very much. I'm buried in a pile of papers on the side here on the floor. So, okay, at this point, I'll open it up to public comment. Is anyone on the line that wants to make a comment on this? I don't hear anything, but I don't know who's muted and who's not. I hear no comments from the public. I see nothing here with putting their hand up or anything like that. So,
Lori indicates that no one has
Lori's
raised.
indicate that no one's raised their hand. Okay, thank you very much. So we'll close the public comment portion. I thank everyone for being here this evening, and I'll entertain a motion to adjourn.
So moved. Second.
Wait, here a second.
Second.
All those in favor signify by saying yes.
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 Yeah.
Any noes? Any abstentions? Okay, the meeting is now adjourned.
Thank you.
Thank
Thank
you all
you.
for attending.
Everybody have a great
I
evening.
appreciate it.
Thank you.
Have a good one.
Good night,
Thanks.
everyone.